Welcome to the fourth video in the Elder Law and Guardianship Training video series for attorneys. This video focuses on multiple topics: limited guardianships, emergency guardianships, and the use of a guardian ad litem. A limited guardianship may be a better solution than a plenary guardianship if the court determines an incapacitated person, or IP, only needs assistance from a guardian for certain types of decisions. In Pennsylvania, judges may specify in the court order the scope and limitations of the guardian's decision-making authority. One alleged incapacitated person, or AIP, may be capable of managing their checking account with a limited amount of funds in it, but needs support to manage bill paying, taxes, and more complex financial tasks. Another AIP might be capable of making some medical decisions, like whether to consent to a straightforward and common medical procedure or test, but needs support in making decisions about more complex treatment options or communicating end-of-life care preferences. Let's check back in with Charlie and Avery at Miller, Jordan, and Wise and hear what they have to say about limited guardianships.
This one is a puzzle. I can see why you wanted me to have a look at it.
Honestly, I'm glad to hear you say that. I keep wondering if there's something I'm missing.
Well, on the one hand, he could clearly use the assistance of a court-appointed guardian to help manage medical appointments, medications, and healthcare-related decision-making.
And he's open to that. He's not afraid to have help. He told me this himself. He said, "I've missed too many important appointments and made too many medication mistakes, Mr. Green. My health is too important for me to rely on myself alone anymore."
That kind of honesty and self-awareness will help him get the help he really needs.
You're not wrong.
It's refreshing in a way. In so many other areas, he's already said he's got a financial planner and accountant he's been working with for over 20 years. He's got reliable and safe transportation as well.
He's fastidious about his home space. Everything is neat and tidy.
And the grocery store situation is ideal.
Yeah, to live 2 blocks from a major grocery store? I mean, he walks there every other day. He's every cashier's favorite customer. They get excited when they see him.
That's heartwarming. Plus, he's healthy enough to make that walk 3 or 4 times a week. I wish all of our clients were that lucky.
The unlucky part is no direct family living anywhere near here. He has a son in Colorado who is financial power of attorney, and he and the son and his local financial planner and accountant have online meetings every other month to check in on things together, so that fiscal side of things is in pretty good shape.
Which is why he doesn't have a guardian of the estate. Fiscal alternatives to guardianship are already in place, correct? Right. If he had a daughter or son nearby who were reliable and willing, they could act as his healthcare representative in the event he becomes fully incapacitated.
Or he could have created a healthcare power of attorney in that case too.
Right. If he had already had something like that in place, we may not be having this hearing at all. And depending upon what Judge Hopper finds, there could be an alternative to guardianship.
Based on what you read there, what do you think Judge Hopper will find?
Well, since Act 61 has taken effect, judges must consider if limited guardianships are sufficient before ordering a plenary guardianship. If I were you, I would make the facts clear to the judge and argue that appointing a limited guardian of the person could be an elegant solution for this particular case.
Of course, a limited guardianship. Why didn't I think of that?
You will now. Don't beat yourself up. I'm glad you checked in about this one.
I am confident my client does not need a plenary guardianship, but he clearly needs something.
It can be complicated trying to recognize just which situations are right for limited guardianships. But zealous attorneys can make a powerful difference for a person in need, especially if all other least restrictive alternatives like powers of attorney or appointed representatives, among many others, are unavailable or simply not feasible for a particular case. Let's check back in with our experts to get their thoughts and perspectives on limited guardianships.
I think that when a person needs a limited guardian, the attorneys involved on both sides need to collaborate to talk about precisely what areas a guardian is needed to assume, what responsibilities a guardian should assume, so that the lawyers together with the judge can propose what should be in the order. Exactly are you proposing a limited guardian to handle all transactions of assets over $1,000? Can the person for whom guardianship was proposed handle money up to that amount, or should it be a different amount? Can the person for whom guardianship was proposed retain the right to vote and meaningfully vote? What are the things that the person retains the ability to do in their daily life, as long as they have adequate supports, as to which they don't need a guardian?
Well, first of all, let's focus on the level of capacity. How much can the person themselves express what they like and don't like, and in what way? If they basically can tell everyone that they're very comfortable in their environment, what they like, what they don't like, if they're feeling pain, not pain, if they would like to do certain activities, great, let's get those on the record. If, on the other hand, you present them with the fact that they simply cannot manage their money in any way, and worst of all, they can be subject to a scheming or designing person, then let's talk about the type of guardianship we're going to need for their estate. If it turns out that they cannot understand that if they stop taking a medication, it's going to be very harmful to them, or they're going to need to take certain medications going forward, again, if they cannot process that, then we need to start looking at that order. Of course, then too, we have to hear from the financial institutions and from the healthcare institutions, what are they going to seek? So there's nothing more frustrating to a guardian or to anyone in our system if they have to constantly come back to the judge.
Crafting a limited guardianship order can actually be quite difficult. We need input from the parties, first of all, as to what are the areas of capacity that the individual retains, and what are the areas of capacity they really need help with. So for instance, if we want to craft a limited guardianship order in the financial area, we might want to say that the guardian is going to make decisions about large sums of money and large investments, and anything over $1,000 or something is within the domain of the court-appointed limited guardian, but that the individual retains the ability to withdraw funds and have a debit card or have some other kind of cash card where they can make purchases and go to the grocery store. And if those things are within their ability, we really want to strive to preserve those abilities for that person. It can be difficult for judges to write this in language that the financial institutions can accept and implement. That's really where one of the challenges comes in. But we're working hard to develop templates for judges so that give guidance as to what's most likely to be accepted by a financial institution, and where are some pitfalls where if we use language that's a little bit too vague, we'll get nowhere and have to start over. So that's the challenge with limited guardianships, but to me, it's really important that we do our best to identify the areas of capacity that the person retains and to help and to permit them to exercise those authorities.
My experience, to make a limited guardianship order workable, you need to be very concise and clear in what you're authorizing the limited guardian to do. If it is vague and subject to a lot of interpretation, then frequently third parties will put limitations on it or refuse to accept it. I prefer that if I know what institutions need and want to see in the order, then I'll incorporate it, either through attaching their language to my order and referencing it, or actually incorporating it right in the order. That can frequently be done with third-party financial institutions if they tell me we need the following language. The same can go though with healthcare systems too. If they want particular language to access a portal or to be able to converse with someone, find out from them what that language is. If the person is likely to seek that or use that facility for treatment or that healthcare professional group for treatment, then work with them and incorporate the language.
had a case years ago with a woman for whom Aging Adult Protective Services sought a guardianship. And the problem at the time was that she had become subject to, or vulnerable to, scams. She was giving money away to, I think, a lottery type scam. She was very insistent that she was going to win the lottery. She was absolutely persuaded. But the truth is, she had tremendous capacities that she retained. She was able to grocery shop and cook her own meals. She was maintaining her home. She actually had friends and activities in the community. She was respected in her community. It wasn't appropriate for her to have a plenary guardianship over her. And fortunately, her nephew, who sought to be her guardian, understood that he wanted to respect her dignity and her independence as long as possible. So he worked with the court, he and his attorney worked with the court to fashion a limited guardianship that gave him authority over her larger financial accounts, but made sure that he was able to, on a monthly basis, give her money into a checking account, and she could continue to do what she'd been doing, grocery shop and cook for herself and keep her home, and go out when she wanted to go out in the community and enjoy herself and live her life, but not risk sending $30,000 or $40,000 to scammers.
Had an individual who had a power of attorney in place. And so the family, though, members thought that they needed a complete plenary guardian because that is what everyone had told them, including the banking institutions. And they attempted to use the power of attorney and were turned away. So what we did in that instance was to incorporate the power of attorney, attach it to my order of limited guardianship, explain to everybody who is going to read my order, please consult the power of attorney. I also reminded them in the order that there can be penalties and consequences if you don't honor the power of attorney. And that kind of reminder, I think, really worked well for allowing then the family to attend to the needs of the person financially without a full guardian. They were able to use a limited guardian order, and that was very effective.
As you can see, when other least restrictive alternatives are not an option, limited guardianships can potentially provide a less restrictive solution than a plenary guardianship. Next, we will focus on the topic of emergency guardianships. As the name implies, emergency guardianships can be implemented by the courts in cases where there is imminent financial or medical disaster looming for a person, unless there is the immediate intervention of a guardian of the estate, the person, or both. Avery has been suddenly asked to attend an emergency guardianship hearing. These kinds of things come up quickly, and counsel must always be as ready as they can be. Charlie is ready to offer him some last-minute advice.
And you just got off the phone with them.
Yes, and I want to be there by 1:30. My meeting with the AIP is at 2, with the hearing to follow immediately after.
You seem weirdly calm about all of this.
Oh yes, I bury all of my anxious thoughts.
No wonder you're good at this. Okay, so you need to eat lunch. So that means I have just a few minutes to help you download a career's worth of emergency guardianship hearing advice. No problem.
Piece of cake, really.
Okay, first of all, we need to quickly review Section 5513.
Pennsylvania Statute Chapter 20, Section 5513 states in part, "The court, upon petition and a hearing at which clear and convincing evidence is shown, may appoint an emergency guardian or guardians of the person or estate of a person alleged to be incapacitated, when it appears that the person lacks capacity, is in need of a guardian, and a failure to make such appointment will result in irreparable harm to the person or estate of the alleged incapacitated person. An emergency order appointing an emergency guardian of the person may be in effect for up to 72 hours. If the emergency continues, then the emergency order may be extended for no more than 20 days from the expiration of the initial emergency order. After expiration of the emergency order or any extension, A full guardianship proceeding must be initiated. An emergency order appointing an emergency guardian of the estate shall not exceed 30 days. After 30 days, a full guardianship proceeding must be initiated.
Okay, so that's all actually fairly clear. So what is your summary perspective on what my role is today?
The burden of proof in an emergency guardianship hearing remains the same as in a more typical, less rushed plenary guardianship hearing.
So they have to prove that the AIP lacks capacity and needs the intervention of a guardian.
Yes, and they must prove that the need is urgent and cannot wait until a regular guardianship hearing, that there is risk of irreparable harm to the person or estate if action is not immediately taken, and that less restrictive alternatives have been explored and discussed.
So I just have to do what I always do, just without the normal amount of time to prepare.
Essentially, yes. Today is going to be one of those days where your calm nature helps you stay afloat.
That's what my uncle said about my LSATs.
The Pennsylvania Guardianship Bench Book can be a helpful reference for guardianship cases and is available on the OEJC website. The Bench Book specifies who can and who cannot be appointed as an emergency guardian. A person nominated by the AIP in a power of attorney or healthcare power of attorney to serve as guardian if needed. Anyone currently serving the AIP in any guardianship role, for example, if an emergency guardian of the estate is petitioned and the AIP currently has a guardian of the person, that guardian can be appointed as the emergency guardian of the estate or vice versa. The AIP's spouse, unless estranged or in the process of divorce. Adult family members are also eligible for appointment as emergency guardians. A person who a parent has nominated may serve as emergency guardian for the unmarried AIP. Another person who can be appointed to serve as an emergency guardian is any adult who has knowledge of the AIP's preferences and values, including, but not limited to, religious and moral beliefs, and would be able to assess how the AIP would make decisions. A professional guardian or other adult deemed qualified by the court may also serve in the emergency guardian role. As for who may not serve as an emergency guardian, that list is a bit shorter, but worth noting. Any person or entity, such as a nursing home, providing residential services to the AIP for a fee cannot serve in the role of emergency guardian. Any person with a demonstrated conflict of interest with the AIP cannot serve as emergency guardian unless there is a clear demonstration no alternative exists. It should be noted that a family relationship between the proposed emergency guardian and the AIP shall not, by itself, be considered an adverse interest. At this point, we will check in with our expert panel for their thoughts and comments on emergency guardianship.
An emergency guardianship hearing is typically requested when there's a risk of imminent harm to the person. That means an immediate and urgent risk. So if there's a medical procedure or medical need that the person has and it's arisen suddenly and they're unable to make decisions or consent to care, that would certainly justify filing an emergency guardianship petition.
Obviously, health and safety are the primary reasons to move forward with an emergency guardianship. I think physical abuse of elders is a topic that is not adequately thought of. I don't think any of us appreciate just how much pride elderly individuals have. They've gotten to a certain level in life. For them, it's a great embarrassment to find themselves in an abusive situation. Frequently also they want to maintain their independence. So if tolerating some abuse to avoid going into a nursing care facility, if that's their option, they'll take the option of enduring some abuse as opposed to being taken out of their own home. We need to be cognizant that that's happening, and we need to be able to hopefully properly investigate it and address it. For me, it's vital that we really take the time to observe and see and hear and listen to what's going on. Because unfortunately, the individuals themselves might not be completely forthcoming about what's happening. And we're not necessarily going to even see it in the courtroom. So there we need the assistance of the Area Agency on Aging, Adult Protective Services, law enforcement, and others, social workers and others, to really make sure we get a clear picture of what's going on. First of all, I think that there needs to be questions raised about what are the immediate needs of the person. And what I mean by that is sometimes it is suggested to the judge that this is an emergency, when in reality, the person is actually safe where they are located. There are enough people now observing what's going on, including maybe the local Area Agency on Aging, such that the bad actors who may be harmful to the person are not engaging with the person. And if those things are done initially, sometimes then you can kind of get a nice pause on the situation, and you can avoid needing to ask the judge for an emergency guardian. That has been my thought frequently. And also, if you can get an attorney engaged with the person to also start asking questions, start representing the person, that frequently that can also lead to the stay for an emergency hearing, because that attorney is able to very proactively let everyone know, I am now representing the person. You need to stop these activities.
Whenever there's a request for an emergency guardianship hearing, I think the court expects that the attorneys will have first tried to avoid an emergency hearing and see whether everything that is needed and decisions that can be made can be effectively made by healthcare decision makers or others until there is a time for a plenary guardianship hearing. There are times when an emergency hearing can't be avoided, but we do expect that counsel will have sought alternatives to see whether they are workable for the short term. Sometimes we get emergency petitions for a person with severe depression who has reached a stage of becoming catatonic, unable to speak, unable to make decisions, unable to participate in their own care. It can become very serious medically and pretty grave. And sometimes the medical providers are recommending therapies that for which a guardian might need to consent. I've had those cases, and after them, in several instances, the person recovered substantially, and by the time we would have held a plenary hearing, they no longer needed a guardian. So a really quick intervention based upon the appointment of an emergency guardian can save someone's life.
I had occasion, again, as a young attorney, to have a family come to me seeking an emergency order for ECT treatment. That was a necessity to reverse the cycle of depression that their family member was experiencing. And it was really a necessary treatment. And I can still remember on a late Friday afternoon, rushing to the courthouse with a petition, seeking to get treatment, coordinating an attorney and an attorney for this person, going through all the steps, getting the physician lined up to testify, and being able to present that to the judge. And it was very, very nice many years later to be walking through the supermarket and to see the couple walking arm in arm, and to know that this person had been essentially returned to their family and living really the life that they should be living.
Our last topic for this video is the use of a guardian ad litem. A guardian ad litem is appointed by the court to protect and look after the interests of someone who cannot protect or look after their own interests. Courts frequently appoint a guardian ad litem for children in family court proceedings. They are sometimes appointed for alleged incapacitated adults, as well as in guardianship proceedings. In Pennsylvania, a guardian ad litem must be a licensed attorney or licensed mental health professional. Judges can appoint a guardian ad litem, but counsel can also request a guardian ad litem be appointed to a case. The attorney representing the AIP/IP in court proceedings cannot also take on the role of the guardian ad litem. These are two distinctly different roles. Job of a guardian ad litem, according to the Pennsylvania Guardianship Bench Book, is to investigate the facts of the case impartially, make an independent assessment of the need for a guardian, and make a report to the court. A guardian ad litem's role may involve disclosing the AIP's confidences and making recommendations which conflict with the wishes of the AIP. Actions which could conflict with the ethical obligations of counsel for the AIP. As such, counsel should not attempt to assume both of these roles simultaneously. However, counsel for an AIP may request the appointment of a separate guardian ad litem if that step would be helpful in protecting the interests of the AIP. For example, if the AIP is at risk of serious financial loss or physical harm and does not instruct counsel to defend against the source of that risk, this would be a circumstance in which it would be appropriate for counsel for the AIP to request the appointment of a guardian ad litem, who would be able to educate the court about the best interests of the AIP. Some steps a guardian ad litem can take to complete their responsibilities prior to an adjudicatory hearing include: first, they should meet with the alleged incapacitated person and inform them of the petition and their rights. They should also inform the IP of their role as guardian ad litem and how it is different from the role of their counsel. It can be confusing for an IP to have both an attorney and a guardian ad litem. The guardian ad litem should clarify the difference and, at a minimum, let the IP know that what they discuss is not confidential and not protected and may be reported to the court. Then, the guardian ad litem must make a professionally informed determination of how the alleged incapacitated person, or AIP, feels about the petition and proposed guardianship. The guardian ad litem should review any medical and mental health records for the AIP that the guardian ad litem feels are necessary for review. Then, the guardian ad litem must interview the proposed guardians and make a professional determination of their suitability to serve in the role of guardian for the AIP. The guardian ad litem should also consult with professional experts regarding the disabilities and needs of the AIP as appropriate. Once the guardian ad litem has completed these tasks, as well as others they or the judge might deem professionally necessary, they should submit a written report to the court detailing all their findings. They can and should include a recommendation regarding the proposed guardianship in the report as well. Let's shift back to the offices of Miller, Jordan, and Wise and see why Avery might have to work with a guardian ad litem on one of his newest cases.
So, you know the Risoli case?
Who's the judge there?
Judge Steinmetz.
Thanks. It just helps me to place it. Is that the one where the two adult children each want guardianship of their elder mom, but they refuse to consider co-guardianship?
That's the one.
I know those two have been hard to work with.
That's an understatement, but yes. Judge Steinmetz did something really interesting at this morning's hearing.
Let me guess. Did she appoint a guardian ad litem?
Wow, you're good.
It's true. I've been working here for a long time. Have you worked on this guardianship case with a guardian ad litem before?
I haven't yet. Anything I should expect?
Well, it wouldn't surprise me if they find information that aligns with your own understandings of the facts of the case. You're thorough in building your case, and you tend to do a good job of separating fact from fiction. That's part of a guardian ad litem's job, in my opinion.
These two adult children seem more interested in not working together than helping their mother, my client, get what she needs.
I'm sure Judge Steinmetz is noticing that too. Based on what you've learned already in working on the case, what would you find if you were her?
I might be inclined to appoint a professional guardian separate from either adult child, given how they've acted around this. Neither of them seem especially capable of doing anything except trying to sabotage the other. They aren't making compelling cases for why they would make a good guardian, only why the other won't.
That's too bad. This isn't the only reason to appoint a guardian ad litem in guardianship hearings, but it's certainly one I've seen before. And of course, there's no guarantee that will be the outcome. But it sounds to me like a case where the appointment of a guardian ad litem is prudent and a helpful choice. Their job is to figure out what they think is best given their experience and professional perspectives. The guardian ad litem will report to the court on what they think is in the IP's best interest. The attorney's job, on the other hand, is to advocate for the client's wishes. It's very possible the guardian ad litem might come back with a recommendation that the attorney has to oppose depending upon what the client wants. All part of the job. The judge will make the findings of fact from the recommendations and other evidence.
Sounds like an important job.
All court-related jobs are important, so yes, friendly reminder. But if you find yourself in a situation where the appointment of a guardian ad litem would ultimately be of interest, you can request one be appointed. For example, if your client's wishes appear to be in direct conflict with what is clearly best for their continued health and well-being, you as their counsel are professionally obligated to advocate for their wishes. But you may also request the appointment of a guardian ad litem to make an independent and researched recommendation to the judge about what might actually be in their best interest.
Good to know.
I wouldn't be surprised if you get asked to work as a guardian ad litem once in a while, once the judges around here get to know your work better. You would be the kind of attorney that would be good at it.
What kind is that?
Thorough, determined, and fair.
Why, thank you, Miss Jordan.
Don't let it go to your head, Mr. Green.
It is important for both judges and counsel to be aware of when it is best to utilize a guardian ad litem and when it is not. Of course, appointing a guardian ad litem is not a substitute for appointing counsel. Guardians ad litem are an optional appointment in guardianship hearings. In contrast, counsel for an alleged incapacitated person is required. Another important distinction that must be noted between client's counsel and a court-appointed guardian ad litem has to do with payment. If there are adequate funds in the client's estate to compensate the guardian ad litem, that can be an option, but ultimately, much like in the event of required counsel, if the client cannot afford to pay the guardian ad litem, the court must find a way to compensate these qualified attorneys for their time in this non-counsel guardian ad litem role. Let's listen to our expert panel and hear their thoughts and perspectives on the appointment of a guardian ad litem in guardianship cases.
The best use of a guardian ad litem is to give the court as complete a picture of the person's financial condition and physical condition, and to be really comprehensive in getting that information. That, to me, is the most effective use of a guardian ad litem.
When an attorney is representing an alleged incapacitated person and they learn what that person wishes to have them advocate in court, if they have a genuine concern that what the person wants is adverse to that person's own interests, is dangerous for that person, it may be appropriate to ask the court to appoint a guardian ad litem for that person. So for instance, let's say you're representing an individual who says they know who they want to be their agent under a power of attorney, and they want their son to be that agent. And you have information that demonstrates that the son is financially exploiting that parent. That would be a circumstance where you have a bit of a conflict. Your client is instructing you to tell the court that they want their son to be their decision maker for their finances and have control over their finances. At the same time, you know this could be dangerous and detrimental to their own interests. That's why appointing a guardian ad litem might be helpful to the court to have a different voice, a person who can look at all the same facts and explain to the court what is in the interests of the alleged incapacitated person. And it's something that perhaps the attorney could not advise the court about due to their responsibilities to their client.
If the person has sufficient capacity to talk to their lawyer and explain what they like and don't like, and that does not really go against the idea that they are making good choices, right? Not harmful choices, then I don't see the need for a guardian ad litem. The biggest concern for me for a guardian ad litem is where the individual is making express choices about remaining, say, in an abusive household because they have affection for the caretaker, or they cannot perceive that the person who is taking their money from them is harmful to them. Then you need to get a guardian. If they're going to make that kind of a case of advocacy, then you want the guardian ad litem, because you want the guardian to maybe give you a full picture of what's going on and to make that best interest advocacy point to the court and to get information, for the court. But if the person seemingly is, even if it's a choice that many don't like, if it's still a reasoned choice, and it may be to, say, stay in their home with supports, if we can accommodate that, let them have that advocacy, right? And you shouldn't have a guardian ad litem interfering with that.
I don't think a guardian ad litem should be appointed in every case. In fact, the legislature made that clear, that the legislature expects appointment of counsel for the alleged incapacitated person in every case, and made clear that counsel should not consider themselves to be acting as a guardian ad litem. So they've made a clear decision that a guardian ad litem is not expected in every case. I do think that where counsel, and the rules of professional conduct address this, where counsel is representing someone and feels that what that person wants and directs the attorney to do will cause harm, that's the appropriate time to request appointment of a guardian ad litem. When the court has determined to appoint a guardian ad litem, I think someone who wishes to do that job and do it exceptionally would make sure they talk to all of the different parties to the case and get a comprehensive view of what the different views of different children or different family members are, what the nature of the conflict is, and try to come to a determination of what's truly in the best interest of the alleged incapacitated person, and then present that information to the court, whether by calling witnesses or by providing an oral report to the court.
An exceptional guardian ad litem is tenacious in getting information for the court, getting information that they can then put into a report and give to the court. They do a lot of interviews with a lot of people in the person's life, and they frequently will not be deterred in getting that information. That's what makes a great guardian ad litem. I think I'm very fortunate in having a series of attorneys who take the guardian ad litem role very seriously. They've trained in this area for both children and adults. They really invest time in understanding what the person's needs are. There are a few that I'm not going to single out, but who regularly are able to explain to me the hours that they invest, understanding the person's background, understanding their life history, understanding who is really interested in the room in the person's best interest. And then they're able to say to me credibly what they think is in the best interest of the person. I don't know that I've ever had a poor guardian ad litem experience. That's also hopefully because we're doing our best to use our guardian ad litems responsibly, so the guardian ad litems aren't overburdened, and so they're not maybe skimping time with one person to accommodate another. And I think that's really, really important too. I think the more guardian ad litem candidates you have, the better for your judicial system.
I did read a recent Superior Court opinion about a guardian ad litem who was appointed before appointment of a guardian. So before the person had actually even been determined to be incapacitated. And the guardian ad litem, in that case, exceeded their authority, in my view, as to what a guardian ad litem should do. A guardian ad litem's role is to provide advice to the court in the context of the case and until the case can be resolved. A guardian ad litem should never be taking over a person's life, managing their money, selling their assets, moving them to a new location. If a person needs that much supervision and control over their life, then they need to get to a hearing, have and have a guardian appointed and have the ability to bring an appeal. But a guardian ad litem has a limited role, and the role is to provide advice and information to the court that the court might not otherwise become aware of.
This concludes our 4th educational video in the Elder Law and Guardianship Training video series for attorneys. Limited guardianships, the appointment of a guardian ad litem, and emergency guardianships all represent nuanced aspects of guardianship legal practice that attorneys, judges, and court staff should be familiar with. Each case is unique and requires a unique approach. For our 5th and final video, we will take a look at navigating client administrative duties and post-adjudication items, guardianship monitoring by counsel, and review hearings. As always, thank you for watching, and thanks for all you do to protect the clients you serve in and out of the courtroom.